Hello, I'm Stuart Evans, and I'm a commercial litigation partner at BLM. Today we're going to tackle the following question. What if my business has claims against other parties as a result of COVID-19? To discuss this critical question, I'm delighted to welcome back Matthew Polly, Corporate and Restructuring Partner at BLM. Matthew, to set the scene, as we emerge from lockdown, there will be countless instances where the supply chain is broken down, leading to non-performance, delayed performance, and cancellations. That may, in some instances, be as a direct result of COVID-19, but not always. How should businesses be assessing their supply chain?
Hi, Stuart. Thanks for having me back. I guess in answer to your question about assessing breaches to the supply chain, the answer is sensitively and with an eye to the future. A breakdown of your supply chain could be fundamental, or indeed it could only be temporary. And ordinarily, the best advice is to review the breakdown, assess the extent of the damage, and consider carefully whether or not that damage is repairable. The supply chain is just that, it's a chain, and the removal of a link from that chain can have far-reaching consequences.
We've heard a lot about the term force majeure. When can that be a fair excuse for a failure to perform?
Well, a force majeure clause is a contractual provision which operates to forgive a breach of the agreement by a party where that breach comes as a consequence of an event outside of that party's control or indeed their reasonable contemplation. It's sometimes referred to as an act of God clause for that very reason, and COVID-19 is a perfect example. To give you an example, say you're a contract cleaner with an obligation to clean a large commercial premises. Lockdown will have meant that you can't access those premises, and therefore your failure to clean them should not be an actionable breach of the contract by the business owner. Now, in those scenarios, even where the contract doesn't have a force majeure clause, negotiation is almost always preferable to enforcement. But not all situations are as clear-cut as the example I've just given. So, Stuart, with the courts remaining open for business, how can a potentially distressed company progress their claims in this current environment?
Well, the courts are under pressure at the moment due to staff shortages, and the situation will not improve if there is, as predicted, a deluge of fresh claims post-COVID-19. That said, the High Court operates an electronic filing system and remote hearings are a regular occurrence, so there is no impediment to claiming. If you have a funding issue, we can find some workable solutions for you, possibly including third-party funders that can provide you with the finance to progress a claim in return for a share of the proceeds if you win. Needless to say, if your opponent is cash-strapped, then you will need to think carefully whether it is worth the risk of suing them if they are likely to go bust before you enforce any judgment against them. If there is no genuine dispute over your claim for a liquidated sum, for example, an unpaid invoice, you may want to think about winding up proceedings, although there are currently restrictions on your ability to do so until the end of September 2020. I've seen some creditors get into an almighty tangle over this, so it is best to seek advice before embarking on an insolvency route.
Yeah, absolutely. So if you have claims or are concerned about the state of your business, get professional advice early on, as difficult situations caused by unresolved claims and disputes can be turned around. Equally as importantly, be mindful of your obligations before you sign the contract, and make sure you take professional advice in good time before the contract is consummated. With the other major challenge on the horizon in the form of Brexit, and the likelihood that force majeure clauses will not cover contractual breaches caused by Brexit, make sure you build the necessary protections into your contract, not just now, but looking into the future as well.
Thank you, Matthew. If you have any further questions or need specific advice, please do get in touch using the details at the end of this video. Look out for part 3 in our What If series, focusing on creditor action. Until then, stay safe and thank you for watching.